You, Howard Celestine? And Mr. Celestine, in cause number 24, DCCR 0919. It might be easier. Y'all can help me out. What level offense is that one?
Which one?
That's the manufactured delivery of a...
Oh,
All right, and you're charged with... All right, in that case, you're charged with the third-degree felony offense of manufacturing or delivery of a controlled substance, and that's from January 10th of 2024. The indictment alleges you were previously convicted of aggravated sexual assault of a child, a first-degree felony, April 13th of 2009. What that means is if you go to trial in that case and you're found guilty, the range of punishment would be that of a second-degree felony, which is between 2 years and up to 20 years. Do you understand? And then in cause number 24, DCCR 1...
Let's pause right here. What the judge just said is critical. This isn't just a simple felony. Because of that prior aggravated sexual assault conviction, every new charge automatically jumps up a level. It's called a habitual offender enhancement, and it can turn a mid-level case into one that carries life in prison. Basically, his past just made his present 10 times worse.
9, you're charged with aggravated assault with a deadly weapon, which is a second-degree felony. From June 24th of 2024. That indictment alleges that same prior offense, which means in that case, if you're found guilty, the punishment would be enhanced to that of a first-degree felony, which is a minimum of 5 years in prison, up to 99 years or life in prison. Do you understand? I'm sorry? And then in cause number 24, DCCR 1550, you're charged with a first-degree felony offense of murder, and that offense date is June 24th of 2024. The indictment alleges that same prior offense, which again, in this case would mean the minimum punishment would be 15 years if you're found guilty, up to 99 years or life in prison. Do you understand? And then finally, in cause number 24, DCCR 1551, you're charged with the state jail felony offense of abandoning, endangering a child, and that's from June 24th of 2024. What it means in that case, if you're found guilty, is the minimum punishment is 6 months in state jail up to 2 years in the state jail prison. Do you understand? In all of your cases, I have plea bargain rejections that you've signed with Ms. Perazzo that shows that the district attorney has made offers if you wanted to enter pleas of guilty for a 45-year term in the murder and the aggravated assault with a deadly weapon, with a 20-year sentence in the manufacturing or delivery of a controlled substance case, and a dismissal in the abandoning or endangering a child case.
That's correct.
Those 45-year term and 20-year term would all run concurrently if you wanted to enter a plea in those cases, which means all together at the same time. You have every right to reject those offers, have all of your cases set for trial. I just want to make sure you understand what the possible consequences are and what your options are. And do you understand all of that?
Yes, ma'am.
And do you want to reject those offers and have your cases set for trial?
Yes, ma'am.
All right, we'll get those set on the trial docket. Ms. Perazzo will begin preparation.
Well, he just turned down 45 years on a murder case and chose to go to trial instead. Think about that for a second. Most people take the deal to avoid the risk of life behind bars. So, is this confidence, denial, or just pure desperation? Let me know in the comments what would you do if it were your life on the line.
Mr. Coleman?
Your Honor, the state anticipates filing a motion to accumulate or stack to the extent that we can under the law.
And I did relay that to
Okay.
Mr.
I'm not sure which of any of those would be
I think the drug case would be the only one that's
That
not
could-
out of that same
the same
occurrence.
occurrence. Okay, and you've gone over that with him?
Yes.
All right, you can go back with the bailiff. We'll set your case for trial. Thank you, Ms. Perazzo. Good morning. Are you Robert Williams?
Yes.
And will your client waive the formal reading of the indictment?
Will, Your Honor.
Mr. Williams, in cause number 24, DCCR 2371, you're charged with the state jail felony offense of evading arrest with previous convictions from October 24th of 2024. The indictment alleges you were previously convicted of evading arrest or detention March 21st of 2024. And how do you plead to that charge?
Guilty.
And is that prior offense true?
Yes, ma'am.
Are you entering your plea of guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes?
Yes.
Do you fully understand them?
Yes.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
And also, do you understand, if you're not a U.S. citizen, a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Williams is not competent?
No, yeah.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent, you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of evading arrest or detention with prior conviction. Sentence you in accordance with that agreement to a term of 12 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I have handed you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Ms. Holmes. All right, good luck to you, sir. You can go back with the bailiff. Okay, did we? Okay, never mind. Got it. Okay. All right, are you Edward Sellers?
Yes, ma'am.
Okay, and I'm going to take judicial notice of the court's file and cause numbers 24 DCCR 0386 and 24 DCCR 1927. Mr. Sellers was evaluated for competency to stand trial previously and was found not competent to stand trial, was sent to the John Dunn Behavioral Science Center for competency restoration. I received a packet from that facility dated November 27th of 2024. The finding in that is that Mr. Dunn is currently competent to stand trial. There's a report of competency evaluation included that has the date of October 20th of 2024. This was prepared by Dr. Stephen Coates. Let's see, is that it? Is there any other information with regard to competency?
No, Judge.
Ms. Malfino, so then at this time, based on that report, I will find that Mr. Sellers is currently competent to stand trial. And so you both...
3. Competency restored. That one phrase can completely change a case. What it means is the defendant now understands what's happening and can assist in their own defense. But here's the chilling part. Sometimes defendants regain competency just enough to face trial. Not because they're truly well, but because the system says they meet the minimum bar. Imagine being declared fit for trial when you're barely stable.
Probably need some more time in the case now that we have Mr. Sellers back, and so is a normal reset sufficient?
It is, Judge. Judge, Mr. Sellers did want me to inquire with the court about his bond. The issue is that he was evaluated while he was in jail. In the interim between the evaluation done and we getting the report back, he made bond. So he was placed on the bond docket, showed up for court, and then was taken into custody to go to the hospital at that time, Judge. So he's concerned about whether it's possible for that to be reinstated or something since he's completed his term at the hospital for his dealing with competency.
So what did I just raise it or find?
It's showing no one because he's,
Right.
Well, I had showed you the $12,000 one on the last.
They're both.
I'm sorry, on the 1927.
So let's do this, since there hadn't been anything filed, I guess technically, we're gonna Ms. Holmes is going to do a little checking into kind of how, on both cases, to make sure
Right.
both cases are kind of the same status, which ones made bond, what those bonds were before he was sent to the Dunn Behavior Center, and then I will take a look at it and see if there's something that I'm comfortable with going back to on that. That way I can review all the reports and things like that and,
No problem.
and take a look at it. If you'll just put it on my desk once we figure that out. All right, you can go back with the bailiff. DeAndre Thomas, Mr. Lewis. Good morning. Are you DeAndre Thomas? And will your client waive the formal reading of the motion?
He does, Judge.
Mr. Thomas, in cause number 23, DCCR 2048, I have a motion to revoke your unadjudicated probation. This shows that you were placed on probation February 27th of 2024 for the offense of obstruction or retaliation, third-degree felony, and that was a 4-year deferred probation. Is that correct? It alleges that you violated your probation. Count 1 alleges that you failed to report as directed to the probation department August 13th, September 3rd, and October 15th of 2024. And is that true or not true? Count 2 alleges that you failed to work faithfully at suitable employment and provide verification of that. And is that true or not true? Count 3 alleges that you provided a urine sample August 21st, August 29th, September 5th, September 23rd, and October 9th of 2024 that tested positive for tetrahydrocannabinol. And is that true or not true? Count 4 alleges that you failed to provide verification of performing the community services required. And is that true or not true? Count 5 alleges that you failed to provide verification of completing the anger management program. Is that true or not true? Count 6 alleges that you failed to provide verification of entering and successfully completing the moral recognition therapy. Is that true or not true? And then count 7 alleges that you're behind in your court-assessed fees. And is that true or not true? Did you enter your pleas of true to counts 1 through 7 freely and voluntarily? And did you plead true to those counts because they're all actually true? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis? Do you fully understand them? And do you understand, if I follow the agreement that you made with the district attorney, that you will be waiving or giving up any right to appeal? State tenders number 1.
No objection, Judge.
It's admitted. Is there any evidence that Mr. Thomas is not competent?
No, Judge.
All right, sir, I'm going to find that you entered your pleas of true to counts 1 through 7 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time find you guilty of obstruction or retaliation. Sentence you in accordance with your agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I have handed you the trial court certification that shows this was an agreement that I followed, and so you've waived any right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Lewis. All right, good luck to you, sir. You can go back with the bailiff. Anthony Young, sentencing. Mr. Lewis. Good morning. Are you Anthony Young?
Yes, ma'am.
And Mr. Young, you were previously in court and you entered a plea of guilty to the second-degree felony offense of theft of a firearm. And I received the pre-sentence report and I reviewed that. Has everyone had an opportunity to review that report?
Yes.
Are there any additions or corrections to that report?
Well, just to judge, I know maybe some issue with the defendant's version of what happened for him to accept responsibility. That was discussed with him, and he does understand, of course, what he was charged with, what he pled to, and he's definitely accountable and responsibility for what happened with that gun there.
Okay. Anything else, Mr. Smith, on that? I have also received and reviewed numerous jail incident reports that I've had an opportunity to go through. Have you both had an opportunity to review those?
I have reviewed them and discussed them.
So the agreement's for a 5-year deferred probation. How old are you? 17. I'm pretty sure if it's not the thickest packet, it's close to one of the thickest packets I have received from jail with regard to how you have been acting and misbehaving, knowing that you're about to come in front of a judge who could either accept or reject your plea agreement. Doesn't make much sense, does it, how you've been acting? So why have you been doing it?
I get irritated easily.
You do? Do you understand? You're 17, you're so young. We all get irritated easily. That's life. It's just part of life. People are going to irritate you. Your parents are going to irritate you. Your lawyer, me, your friends, your girlfriend if you have one, your wife if you end up with one. We all get irritated. But you don't act like this, and you don't talk to people who are just doing their job the way that you speak to these correctional officers. The disrespect that you're showing people who are just trying to go to work and make a living is so unacceptable that I'm not going to say the words because people are watching and it's so inappropriate. It's ridiculous what you've been doing. And then thinking that you can get high or a little buzz by drinking hand sanitizer. That was dumb. You ended up in the hospital, right? Do you want to kind of have a normal life like the rest of us and go to work, go home, have a family, go to school maybe?
Yes, ma'am.
Or do you want to spend your life in prison?
I don't want to go to prison.
You don't? So let me just tell you, the way this is looking, you're going to have to make some huge changes in your life if you don't want to go to prison. You're going to have to do things that most 17-year-olds don't do. You're going to have to grow up real quick because you're going to be on an adult felony probation. And so if you don't follow the rules, it's not just a slap on the hand, or it's not just getting kicked out of school and going to alternative school. It's not those things. It's prison. And it's going to be prison for up to 20 years. You can go to prison for up to 20 years if you violate this probation. Do you understand? Let that sink.
This right here is heartbreaking and powerful. A 17-year-old facing up to 20 years if he slips up on probation. The judge isn't just lecturing. She's giving him a second chance disguised as a warning. You can almost hear the frustration. She sees potential, but she's seen this story go wrong too many times. Will this kid finally wake up? Or is he heading straight back to the system?
20 years of your life you could spend in prison for this very case right here if you don't follow all of the rules. It's a lot. So you need to don't get out of jail and then forget this conversation. Okay? I'm going to do some things, hopefully, that will give you some tools up front in your probation so that you can learn how to make better decisions. Not hang out with the same people, get away from all that. It's just going to be up to you. It's not going to necessarily be easy, but the alternative is really not easy. It's prison, right? Okay. What I'm going to do, Mr. Young, is follow the agreement that you made. I'm going to find that you entered your plea of guilty freely and voluntarily. I'm going to find sufficient evidence to find you guilty, but I'm not going to do that. That means today you're not a convicted felon. All right? We're going to talk some more about that in a minute. You're going to be on probation for 5 years. You're going to be ordered to pay a $500 fine. You're going to order to follow all of the rules, all of the conditions of probation. You don't get to pick and choose which one and go, well, I didn't get a new case, but I missed going. Or I didn't get, a lot of people think as long as they don't catch a case or they don't get in trouble again, that they're fine and they don't have to do the other stuff on probation. You got to do it all. You got to report when you're supposed to. If you test positive for drugs, any drugs, including marijuana, and I get that a lot of people don't think that marijuana is a big deal, but it's a violation of your probation. You can go to prison. It's just that simple. All the rules apply, not just some. And if you do that, then this opportunity is your day to change your life. I am going to order as a condition of this probation that you enter and successfully complete the cognitive track of the ISF program. That's a 90-day program. You'll go from in custody to that program. It's an in-custody program. It's not necessarily meant to be a punishment, but it's classes and tools so that you can make better decisions. If you go to ISF and you act like you've been acting in jail, they let me know. We bring you back. Your probation's revoked before you ever hit the streets. So you can get irritated in ISF, but you better not act like this because you'll never even get the chance to be on probation. Do you understand what I'm saying? There's not going to be a second chance if you act like you're acting right now while you're in ISF. That's going to be your chance to prove to me that this nonsense you can grow out of just like that overnight, because it has to be overnight. I don't care who's irritating you. Do you understand? Okay. So when you get out of ISF, hopefully you're successful. You take advantage of it. You're never going to be a convicted felon if you do everything you're supposed to on probation. Being a convicted felon changes your life in all kinds of negative ways. Obviously, you can't get certain jobs. You can't live certain places. You can't go to certain schools. It puts you on a path that's very difficult. You don't have that right now. If you change your life and you do the right things, at the end of this probation, if you're successful, the case is dismissed. You're never a convicted felon. The other side to that, though, just like I've been talking about, is if you violate any condition of your probation, you're back here in court. Your punishment is up to me. I could give you as low as 2 years. I could give you anywhere in between, up to 20 years.
This is the moment that defines so many young defendants. The choice between rehabilitation and ruin. The judge literally lays out the two paths. Complete probation and walk free, or violate and spend decades in prison. The courtroom may be quiet, but what we're watching is the split second where someone's entire future hangs in balance. Real talk, how many 17-year-olds could handle that kind of pressure?
Do you understand? All right, I'm going to hand you the trial court certification that shows that this was an agreement that I followed, and so you've waived your right to appeal. I really do hope you take advantage of this. Another thing I want to make sure you understand is there's going to be a little bit of time between now and when they take you to ISF. It's not very much, but it could be a couple of weeks or so. If I find out that you have incident reports between now and then, before you ever get to ISF, it's a violation of your probation. Does that understand? I know there's a bunch of you young kids that are all in the same dorm in our jail because we got younger and younger of y'all doing stuff like this. And y'all all are in there. I've read all about it in your case and everybody else's case. And you've got to kind of show who's cool and who's not and all of that. If you continue to do that and think you're cool in there, you're going to get to show how cool you are in prison. And that's a whole lot different. And that's not what any of us want for you. Okay? All right. You can go back with the bailiff.